Today we have William Patton. He's professor at Whittier Law School and UCLA School of Medicine, Department of Psychiatry, and he's going to get started with ethics. Is it broadcasting to...
It is. They're having trouble getting on. They're having trouble finding the email with the Skype.
Wait.
That's up to Danielle.
I'm going to wait a couple seconds to see if they
like
can
a couple seconds. I know people may have questions, so I just want to be... They usually leave it all.
I don't have any answers. Let me know when...
I'd go ahead and start because she's having difficulties with it.
We're starting. I was going to welcome those in the satellite units, but you may not hear us, so we'll go. You're going to have to... I have the latitude now to say what I want to say, so I'm going to do a little bit of background. This is an anniversary for me this year. This is my 40th year practicing dependency law, teaching dependency law, and writing about dependency law. And I wanted to get a sense, just so I know the number of years people have practiced, how many of you, along with me, tried dependency cases in the O.J. Simpson Criminal Courts building at 210 Temple downtown? Okay, there are a few of us. How many people remember when termination of criminal rights cases were separate cases de novo under Civil Code Section 232? All right, so we got some old timers here. How many of you have fewer than 2 full years of dependency practice? Significant number. Okay, so the nice thing about that is you haven't seen me before. I've done lots of these for Ladle and CLC, so at least you haven't experienced this before. Again, another thing that I have the latitude to do, this is something I'm very proud about. My daughter and I just published our first article together. She got her MD and her PhD from UPenn and got her MPH from Harvard. And where's Ken? Ken? I want to put this article in the library. I don't know what he reads, but in case you do. It's a new article we just wrote on something that's becoming a hotter and hotter topic, and I've got every citation to every article written up until about the last 6 months on polyvictimization. It is a new diagnosis that we're dealing with at the School of Psychiatry in terms of the most seriously emotionally and physically abused children. And so it talks about polyvictimization, gives you all of the citations to all of the articles. The very first time polyvictimization was mentioned in a California court was 2015. So it's really recent. It's just now starting to come into the discussion in terms of criminal law. Ironically, this is a concept that was developed to recognize different kinds of psychopathology and then to treat them in the psychiatric world. But ironically, the first California case was a criminal case in which the defense attorney used the concept of polyvictimization to impeach the credibility of a child witness. So it's something you may want to think about. So if you haven't heard about it before, this is an article which, again, I'm leaving for your library. Can help you kind of get a sense of what's going on, and then if you have questions the next time I come, we can answer those as well. A lot of people think of legal ethics as just rules that you have to follow that constrain your behavior or require you to do certain things. And again, having practiced in this area for 40 years, I see ethics and the rules of professional responsibility as one of the strongest swords that a parent's attorney or a children's attorney can possess. Many of the cases that I've decided, I wish I had been on the court, many of the cases that I have argued in the California Supreme Court on dependency law have revolved around concepts of professional responsibility. Some of the cases like Josiah Z, a case that was to determine whether or not an appellate counsel in a dependency case could have a budget to travel to talk to a client about how to represent the client in a dependency case. Again, what I was able to do in the court was to convince them is that part of being a competent counsel is an opportunity to talk with your client, and those funds should be compensated by the government to increase that kind of zealous, competent representation. Another case, Celine R., the one that first established conflicts of interest among multiple siblings. That case we based on, and the argument was pretty amazing because county counsel made an argument that the California rules of professional responsibility simply don't apply to child clients because they lack capacity. So what I did in oral argument was basically call the county counsel an idiot. You don't know what you're talking about. California has never, like the ABA, established a separate code of professional responsibility for children who have a different capacity than adults. We, throughout the code, talk about a client. We don't talk about children versus adults. And it impressed the court to a degree that they were kind of shocked that county counsel would making these kinds of arguments. I'm not going to talk about all the things, but you know, there are certain things you have to do as a child advocate that involve ethics that are outside the courtroom as well. One of the most satisfying victories I've had ever as a parent's advocate was fighting Judge Nash's open court order. Now you know what happened in the AC case. I mean, basically I was involved in that as amicus, but behind the scenes, what you probably didn't know is that I filed an action with the Federal Department of Health and Human Services asking them to withhold $45 billion in child abuse funding until Judge Nash closed its courts. I engaged in multiple Freedom of Information Acts. I got all kinds of data. I've got all of the emails going back and forth among everybody in the state of California in terms of this issue, what they did and didn't do. And I filed 3 separate briefs with HHS, and it was actually based on that action that no one heard about that Judge Nash modified his order, and ultimately the case held that he had abused his discretion. So there are lots of things you do kind of outside the courtroom as a parent's advocate that is wonderful because we have a very active legislative group within Ladle, and I think that's where we can accomplish many of the things that can't be accomplished in court. I mean, think about it. For 30 years, the appellate courts in California, and again, this is ethical issues, for 30 years, the appellate courts in California held there was no right to competent counsel, even if counsel were appointed for a parent. There was even a court, Arturo A., back in the 1990s that said there's a distinction between counsel that's appointed pursuant to a statute, because we finally, in 1994, got the statute requiring competent counsel, but there's a difference between counsel that is given to a parent based on a statute versus a constitutional right, which doesn't ripen until the termination of criminal rights under Santosky versus Kramer. So, you know, these ethical issues are brought to bear to bring due process to our clients. So ethics is not just you shall not or you shall, it is a weapon. It is a powerful advocacy weapon that you can use in the courtroom as well as outside the courtroom. Because why? It talks about controlling authority, but the other thing that an argument based on ethics does is it embarrasses the government. If you establish an ethical standard and they're violating it, you can embarrass them into making changes. I'll talk about the ugliest word I know in the dependency universe. You're all thinking, what could that be? Caseloads, okay? We could not, without the help of the ABA and without concepts of zealous and competent representation, have even started to make a dent into caseloads. Obviously, we're not there. We have lots of work to do. In fact, as you can see, this is part 1. I was sent, and there are 2 names on here. I see Danielle and I see Rachel. They said, we'd like you to talk about ethics. and they sent me 20 questions that you all want to know. So this is part one, only part one of what we're going to do. I'll be coming back to answer more of the questions at another time. We just installed this, hopefully it works. It does. Now, what you can see is that I'm a fraud. That's the beginning. We're talking about being ethical and competent in the face of conflicts and caseloads. Not talking about that today. That's part two. Why am I not talking about caseloads and competence? It's because right now, the California Ethics Revision Commission is revisiting all of the rules of ethics in California. In fact, they are looking at, to give you an idea, just on one separate issue, which was one of the questions I was asked to talk about, the relationship between attorney and client in decision-making on a case. I'll be doing that in part two. It's like 14 pages, just talking about whether we should modify our rules. I would expect within about 6 months the Supreme Court is going to make a determination on these new standards. They're even all renumbered. So if you know some numbers now, like 1-300, those are all being changed. So we're going to have, I'm hoping by the time I come back, we're going to actually have answers. We can talk about how those changes will affect your life in representing parents in dependency cases. But you can see lots of issues dealing with the relationships of clients and attorneys, conflicts of interest issues will be coming forward, how we decide advisor. Are we going to expand that to where you are required to advise your client on not only legal, but non-legal consequences of their lawsuit? That's the ABA rule, which we haven't ever adopted. It would expand it dramatically into, well, how am I going to have to counsel them about consequences of this action in a concurrent or consecutive criminal case? What if they do an action or make an admission? How might it affect their loan that they currently have? How about if they make an admission that they possess drugs? Could that be used against them in an unlawful detainer action if they're in federally subsidized housing? So, you know, there's so many issues that would expand the scope of our advisory capacity if they modify the rules. And I did want to talk about it now because it's kind of supercilious and it's going to be changed today. Here's what I recommend. If you have an ethical question, call the State Bar Ethics Hotline. Now, why am I advising that? Well, actually, I've used it many times. It's been helpful. What will happen is you will call, you will leave your number, they will call you back. Has anyone used it recently? It has about a 2-day period that it will take you. I actually called them, and this refers to another issue we're going to be looking at later, files. I actually called them at 9:11 this morning and spoke from 9:11 to 9:15 just to find out how active it is and what the backlog is. About 2 days it takes. They will give you a library of things to consult. They can't give you legal advice. But why is it important? Not only can you, if you have time, or if you are a government or a quasi-government organization, you can actually, the things you want to do, you could pose the question to them. They'll do a lot of research for you as an institution or as a corporation to decide whether you want to do something or not. I've got a slide coming on one of those issues in the future. So they can actually help you decide how you want to proceed on any kind of ethical question. But there are a couple of other reasons. Let's say that you're sued for malpractice. Or let's say that one of your clients, so they'd never do this, one of your clients turns you over to the state bar because they think you've been unethical. Well, what are the standards for malpractice and what are the standards for ethical violations? What would the reasonable attorney do in similar circumstances? And so if you have called the hotline, you've gathered all the materials that they suggested, and you relied on them, it's not a defense. But what it does, at least, is demonstrate that you acted reasonably, and it could actually help you in terms of the discipline that's rendered to show that you were less culpable than someone else because you did everything within your power to to find out what the proper ethical position would be. So I recommend, if you're having problems, oh, the other thing is, it's confidential. They don't disclose it. But what I asked them, and I had never asked them this question before, I said, yeah, but wait a second. I want to use it to protect myself. What if I am in a proceeding? Can I either have someone testify or get a government document saying that I consulted you? And they said yes. Okay, so it is evidence for, it's like an insurance policy to protect you. Okay, we know that the general, you're supposed to be competent. Language and ethics is purposefully, intentionally vague. And why is that? Because attorneys write it and they don't want to write it too strictly or else they're going to violate. So everything is reasonable, right? Everything's going to be reasonable. So we'll get into what that really means. The first issue that I was asked to talk about is we have a lot of clients, and some of those clients are taking an inordinate amount of my time because they basically want me to call them every 5 minutes, update them, give them documents. What are the rules of ethics in terms of the minimal responsibilities of an attorney towards a client and keeping them abreast of information and communication? So that's our first question. I know no one's ever had a client like this, but assuming at some point you did. So basically what we see here is that you have a duty to maintain regular communication with your client, and these are the rules that establish it. And here are the specific standards. So the first is that you must keep your client reasonably informed. Okay, well, there is no litmus test for that. So the question would be, if you were sanctioned, or if they attempted to sanction you, what would the reasonable attorney do? Well, what does that mean? If you're talking reasonableness, you're talking totality of the circumstance test, right? You're talking, if an attorney has a caseload of 250 clients, can they reasonably, every 5 minutes, be expected to communicate with their client? Well, the client might think so, but a disciplinary board, or if they're suing you for malpractice, they're going to see it very differently. Because what are you expected to do? You're expected to operate like a reasonable attorney within the legal environment in which you practice law. That's both malpractice as well as discipline. You're only expected to do what's reasonable. Not what is possible, it's what is reasonable. Going further, you only have a duty under California Rule 3500 of keeping them abreast of significant developments. Again, not defined, but within an industry, what we do, if we're talking about any kind of discipline, is we look at custom. Custom is what? We learned in the torts class. Custom is not the equivalent of reasonableness, but it's circumstantial evidence of what the industry thinks is reasonable. So if we're talking about significant developments, is a minute order that basically just says, come back next week, a significant development? I'm not going to answer these questions for you. I'm just saying, if in fact the parents filed a 388 change of circumstance petition asking for a change of custody order and it's denied, is that a significant development? Well, yeah, obviously we're getting closer to something that's significant. But that's the standard. You are not expected to notify your client about every single little detail and fact that occurs in the case. And it has to be a reasonable request. Again, now what are we defining? Not the reasonableness of the attorney, but the reasonableness of the client. Copies of significant documents. You are supposed to provide them. I know there have been a couple of cases in the last year where the clients have been asking for almost every document. I'm going to drop that here. There is no discipline for failing to communicate insignificant or irrelevant information. So if your client keeps saying, hey, I want my car painted, find me a place to get my car painted, obviously that's going to be irrelevant to the case. And here's a question that someone had that I'm tying together with it. It was a specific one on the list. In an employment agreement, the attorney may contract for the client's responsibility for the cost of copying significant documents. So the question that was posed by one of you, I'm not going to answer your hand, by one of you is, can we charge our clients for copies? Now, there is no answer to that question. But what it says is, under certain circumstances, you can. Now, as an organization, there are things you need to think about before you establish some, either a sui generis case where you have a ridiculous client that's asking for mounds of data, or as a routine policy. You would have to see the ramifications between an ordinary client-lawyer context and one in which at least the client has been found to be minimally incapable of hiring an attorney, and you've had some designation of whether or not they qualify for need. There was an interesting article, I just read it this morning. It's Making Families Pay Charting Juvenile Administrative Fees. It's an article by Siblin and Campos, and it's part of the UC Berkeley Public Law Research Series, in which they argue that charging indigent or poor clients for these kind of administrative costs have significant detrimental effects on the possibility of the family reunifying, coming together, and coming whole. But nonetheless, from my perspective, this is the kind of question. Can a law firm that represents either indigent or poor families charge them for copy? And that's the kind of thing you send to the ethics hotline and ask them for an answer as an organization. And then you have to worry not only about can we do it, should we do it, and finally, if we do it, what kind of public relations issues might develop based on it. So that, again, this was a slide that was supposed to be responsive to whoever asked that question. Yes?
How about if you have a client who wants to have a specific expert come to testify, and that expert is outside of what our normal practice is, not on our list, but is relevant to the case, but just somebody that's too expensive?
You know, I would like to answer that. I can't right now because, again, that particular issue of who makes the strategic decisions in the case is being changed as we speak in California. But generally, what you're expected to do is bring a qualified expert. Has anyone in here read a specific case, unless it's the only expert in the world that exists in this particular topic? That has happened before. That might raise a different issue. Anyone read an appellate opinion that found any kind of either ethical violation or due process violation based on the unwillingness of an indigent defense firm to call a specific expert witness? I'm not aware of one, but who are our appellate specialists in here? Oh yeah, they don't come to my talks. Okay. Yeah, they know it all. Okay. So I'm sorry, I don't have an answer to that. It's a great question. I mean, it would seem to me that unless that's the only expert that can provide the kind of competent expert testimony necessary to represent your client, that's similar to them saying, I don't like you as an attorney, I want, F. Lee Bailey when he was alive or something. So it seems to me that they would have the burden of demonstrating that your expert was not sufficiently adequate. But I really don't know. It's just we're thinking through it. Okay, we're still on the same thing. What are your responsibilities? You have a duty to respond promptly to reasonable status inquiries, significant developments, in the matters the attorney has agreed to provide legal services. So again, scope of representation defines ambit of duty to communicate. Okay? So if,
Excuse me a moment?
Yes.
I apologize. There was a question from our satellite office. Prior to a Marsden hearing, if we have reason to believe our client may reveal information that will inadvertently provide damning evidence to support an allegation, do we have an ethical duty or any duty to ask that the Marsden hearing be heard by a different judge? I'll try that again.
no, I understand. Something I've given great thought to. Last night I couldn't go to sleep because of this question. No, first time I've thought of it. Let's as a group help answer that question, right? Okay, so you obviously have a responsibility as a zealous and competent representative to protect your client. I have made arguments for years that there should be a law and motion court in dependency law so that your legal issues can affect the fact finder who's hearing the substantive question. I think this is analogous to that. I think that if you have a legitimate concern, again, we're thinking this through. This is not my answer, but we're thinking it through. It seems to me that if you have a legitimate concern on the fairness of the process and you have an available remedy, or you know of an available remedy even if it is denied, which could be a writable or appealable interlocutory writ or an appealable issue for the appellate attorney, that you probably have an ethical responsibility to protect your client. That's my just kind of thought process. But I give a lot of provisos there. One is that you think your client is going to be prejudiced. Another is that you have a reasonable alternative that you can proffer, and that will both possibly help your client now or save that issue for appeal. Because if you do nothing and the issue was there, you've waived it by not making the issue.
I'm not clear whether the concern is for the client in other proceedings, because the records for a Marsden hearing are sealed. So unless they're concerned about affecting it would affect the judge's decision.
That's the way I took it, but I don't know. Do you?
They haven't responded back.
Okay. That's the way I took it, is that what we're really trying to do is prevent infection of fact-finding on the substantive issue.
But wouldn't a judge be reasonable and be able to set aside that?
We're talking about two different concepts, and I'm going to talk about that again. We're talking about psychological literature that has done empirical studies on biases and generalizations of judges. That's a reality. Versus the law's presumption that a judicial officer is neutral, detached, and can unring a bell. Okay, we know all that law, right? Okay, so we're talking reality versus legality. And if you know the reality, and the reality is you don't think that, and even if you have been before that judge, you don't think that judge has the capacity, then you make the argument. What's the worst that's going to happen? As long as the client is consenting, you're not disclosing confidential information, worst that can happen is they say no. We're not going to do that. And then again, that's the choice of whether or not the appellate attorney wants to use that as leverage during the appellate process. So again, this is off the cuff. I'm not filing a brief on this issue, but just it seems to me it's very similar to issues I've made many times to Judge Nash and all his predecessors, Judge Boland back in the old days, that we should have a law motion court here. It costs too much. You know. But my argument is always that our client should get the same kind of representation as Donald Trump. That was a great question. Meet regularly with clients, what does that mean? Again, we're going to look at the industry. You've got 250 clients. You're not going to be meeting with them on a daily basis. Okay, let's change to issue number 2. One of the other questions I had was, in terms of confidentiality, what if my client says something to me that I think is dangerous? Can I report that client without getting into any kind of ethical problems?
Nope.
No. Okay, that's one answer. Yep, is another. And maybe is another. Okay, so let's go through what the rules are. The ABA for 40 years has had a rule that basically says that if your client tells you that they are going to, this is not past criminal conduct, if they are going to commit a crime against an identifiable individual that would result in death or serious bodily injury, you had the capacity to report that, try and stop it, and it would not be an ethical violation. California, up until 2004, refused to follow the ABA guidelines. But now we have a different rule. Now it says, an attorney may, but is not required, to reveal confidential information relating to the representation of a client to the extent that the attorney reasonably believes the disclosure is necessary to prevent a criminal act that the attorney reasonably believes is likely to result in death of or substantial bodily harm to an individual. If you remember back to your torts class, this sounds a lot like the psychiatrist's duty in Tarasov. But there, it's a duty to report. Okay? This is a step very far away from that. You have no duty to report. You may, but you have no duty to report. Well, what does that tell you? Okay? What that tells you is, if you don't report, you can't be sanctioned. If you do report, there are consequences possibly, right? So it's a rule inherent in its structure that provides a disincentive to engage in what we would call good Samaritan action by trying to protect another individual. So there is no duty to report. However, now, since 2004, it is discretionary. Now, before you do that, if you decide to engage in this, and again, think long and hard before you do it, because there could be consequences. Look at what you're supposed to do under the rules. A good faith effort to get the client not to commit the criminal act. So you counsel with your client. Okay? After counseling with your client, if your client convinces you that it's no longer reasonably certain that the act might occur, you no longer have a discretion to disclose. Right? Because that first element, where you have to have a reasonable suspicion, no longer exists. You cannot. So if your client in good faith says, I won't do it, I understand, it's going to screw up everything, that may be sufficient to undercut the standard with which you are provided with discretion to disclose. So again, be careful. Then you must inform your client at an appropriate time of your ability or decision to disclose. This is very controversial. Now the reason it's very controversial is because, okay, you sit down, hi, I'm your attorney, let me tell you, if you tell me something in terms of a criminal act that could lead to death or serious bodily injury, I may turn you in. Okay? That can infect the quality of the attorney-client relationship so that they won't tell you confidential information that is necessary for you to defend them. Okay? That's why the bar has not set up in California. They have not set up the time at which you need to disclose to your client that this may happen. So in California, if you discover something and then you want to tell them then, not at the initiation of the attorney-client relationship, you can do so. They have not established a particular time within which you must disclose. Disclose no more confidential data is necessary to prevent the future criminal act. This is really important. It's not past behavior, right? You can't report, oh, he abused his daughter or something, even if it's a child advocate. It's future criminal conduct. And the whole idea is we will suspend the duty of confidentiality in order to provide some kind of intervention to prevent a very serious injury to another person. And you can only disclose those facts that are absolutely essential. If you go beyond what's necessary, then you're subject to violations as well as malpractice for having disclosed client confidences beyond the necessity created by this exception. So you have to be very careful. And once you do it, there is a presumption that the attorney-client relationship no longer can exist and you must seek to withdraw as counsel. Now I know a lot of you with your obstreperous clients would like to implement this so you get rid of them. But this is a very, very serious section of the code to implement. You have to withdraw. And again, the section is set up so there's kind of a disincentive to engage. There is no sanction for not reporting. So if it turns out I mean, yeah, I mean, putting your head down on the pillow at night because you didn't report, that's one thing. That's your own personal tragedy. But if you fail to report and your client does commit a criminal act of death or serious bodily injury, there is no sanction against you because there is no requirement to report. Any questions? I want to be clear about that because, you know, a lot of people took legal ethics before the rule was promulgated. This is a radical change in California, so if you have any other questions, I'd like to clarify that.
Just one real quick. If anybody has call out, the satellite officers are asking if you could repeat the question or the comment so that they can hear it, because it's hard for them to hear with the setup we have right now.
Where's the mic?
The mic is on the one that's pointing at you. One with your face on it. There.
Hi. The question was, if your client tells you something that could be serious in terms of injury to another person, can you report it? As you see on the slides, it says that it's discretionary. The slides set up all of the procedures that you must implement before you report it, and it is not required, although it's permissive.
I do have a question.
Yes.
You were giving a hypothetical about the client doing the future act and you not disclosing it.
Yeah.
If at some point the client volunteers that he told his attorney he was going to kill or do whatever it was, do you then become a co-conspirator?
That is an area beyond my expertise. As I understand modern co-conspirator rules, which are nothing like the common law, if you live in the same universe, you could be a co-conspirator. I mean, they're so broad now. I don't have an answer to that. I don't know. I've never read a case. Let's put it this way. Very clearly, you could be charged. I have not read any case in which someone has been convicted, and I haven't seen a tort case, since there is no duty like in Tarasov that has upheld a verdict against an attorney.
Plus the rule says no sanctions for not reporting, so I would
No, this is disciplinary sanctions.
I would think it would carry over to the criminal.
I think it would be persuasive
I mean-
that you were following your legal duty.
My view of rules of professional responsibility is they're normally, in fact, many of them are drafted to say that they are not creating a new civil cause of action if you do certain things. Now the difference, if we remember, again, going back to law school, Tarasov, the difference is you get immunity. If you have a duty to report in Tarasov and you report and then you're sued, you have immunity. Well, there's no immunity here. That's why there's a grand disincentive to get involved in all of this. Now, if personally you can't live without reporting, then I'm giving you the procedures for implementing if you just have to do it. But I would strongly recommend before doing this that you talk to your supervising attorney, you have a discussion about the consequences, the necessity. You want a sounding board on something like this before you do it individually, because it really is a dramatic move. Moving forward, new issue. Now, I'd never thought about this issue before, and I was preparing for this, and I thought about it and thought, well, maybe there's no issue, but boy, it's an interesting issue I haven't seen resolved. It says 317E, which I don't know if you know my work, but I've written probably more about 317E than anything. I think I have like 9 law review articles on 317E. It's the worst written thing I've ever seen. Counsel for the minor, quote, may make recommendations to the court concerning the child's welfare and participate further in the proceedings to the degree necessary to adequately represent the child. Now, years ago, I remember a few cases, and the examples are these. So we're in court, and in closing argument, the child's attorney tells the court, you know, based on a conversation I had with the child last night, I just don't think it's fair, and I think it's dangerous to return the child. Another one, you know, I went out and did a personal visit to the home, and based on the conditions I saw there, I don't think it's a safe place to put this infant. Well, look at the next rule, which no one ever thinks about in dependency law. Why? Informal proceedings. Everybody's friends, and we all have our special courtrooms, and you got to process thousands of cases a day. Let's spend 3 minutes a case or 2 minutes a case. But we got to think about it as zealous advocates. In representing a matter to a tribunal, now I don't know if you think juvenile court judges are tribunal, but legally they are, okay? These are tribunals. A member shall not assert personal knowledge of the facts at issue except when testifying as a witness. Well, for me, when I read this rule, because I was going through all these rules again, I'm thinking, damn, there have been times when county council and when the children's attorneys have done that. They've testified to personal information. Do I have a right at that point to object and to call them as a witness and cross-examine them? I'm not giving you answers. I'm saying this is an interesting question in terms of some of the things that I've seen happen in these informal proceedings. So, in terms of when the minor's recommendations, the question is, when does a recommendation or participation of the child's attorney translate from recommendation to testimony, which would be circumscribed by the rule of professional responsibility? And at what point do our parents' due process rights get violated by these informal colloquies by presenting personal information to a judge that could be used against our client? So I have no answers for you. I just thought it was an interesting issue to raise because I'd never thought about it before. I was reading this rule saying, wait a second, this has happened to me, and I really didn't see it. So if we have to be zealous, competent advocates, at least something to think about. And the other thing that it does is it, what? Puts a silver bullet, you know, in your pistol. If you need it in the courtroom, all of a sudden you can say, well, wait a second, Your Honor, she's testifying. Rule of professional responsibility doesn't permit testimony. And what's the response going to be? Closing argument is not evidence, it's not testimony. That's exactly correct, Your Honor. Because it is not evidence, and because you're given new facts where we didn't have an opportunity to cross-examine and confront, this is a due process violation, and we should have a right to putting the attorney on the stand, whatever you want to do about it. I just thought it was curious. I hadn't thought about it before. So this is what I do at night. All these little musings. Sounds like another law review article. This is a new question. There was a question. What is adequate file documentation? Well, I have the answer. There is no answer, right? It's an art. Okay? But in my own mind, when I'm litigating a case, this is what I think about. First is, think of file documentation as a means of defending yourself from the most unreasonable client you've ever represented. Okay? You don't know where this wonderful civil relationship with the current client is going to devolve into a parade of horribles. So if you keep in the back of your mind that you're dealing with, even though they're nice and everything that's getting along, my standard is, I want to protect myself against the worst client. Okay, that's the way I always think about it. Yeah, I'm a pessimist. Then, follow Jim Comey's advice. If you think something is problematic, memorialize it. Right? I mean, this guy was brilliant. Every time he got a sense that something was not right, he memorialized it. And what did that do? That gave him protection. Gave him protection. The attorney malpractice standard only requires that you act as a reasonable attorney with similar training would. If you document why you made a decision, it will help demonstrate that you acted reasonably by trying to do the right thing. Having something memorialized is important. When I teach at the School of Psychiatry, I teach charting, medical charting. And what I do is I teach them how to protect themselves against medical malpractice. And file documentation is an insurance policy. What I tell the doctors all the time, because you know they can't write, my adage is, when in doubt, scribble it out. Just scrawl a note in there for yourself. Because what does it show? It shows you didn't just shoot from the hip. You thought it out. It gives you a means of explaining why you did certain certain things, even if what? Even if they may not be custom in the industry. It shows why you deviated from norms, even if you deviated from a norm. My students in the School of Psychiatry, often when they represent children, have to go what's called off formulary. They have to give a drug to a child where we do not have scientific proof of the exact dosage. So I have them chart it out, saying, this is the best of my ability. We do not have this data, but this child needs this kind of medication. It's the same thing for protecting yourself. It's a good insurance policy to just jot something down. I know with hundreds of cases, it accumulates. It's burdensome. What would Kobe Bryant say? Put on your big boy pants and just protect yourself, right? Just, you got to do it. It's another one of those things that seem like drudgery, but all of a sudden, a year later, a case pops up. Your memory is a little cloudy of what you did. If you've memorialized it, you've got it there to protect yourself. You've got your records. Issue number 5. This is something that never happens, but I want to raise it as an ethical question for you. And actually, this is something that needs probably intervention with discussions with supervising judges, things like that. I'm not asking each of you to be a knight in charge, but what we know is we must be competent and zealous advocates for our client. If I've done a lot of corporate law too. When I go into a corporate case or I have a major tort action where I'm representing a plaintiff, I never waive opening statement. Now, when I was a public defender, I would often waive opening statement from my defendant because there was a strategic reason. I didn't want to disclose data that I didn't have a duty to disclose. I wanted to see their case, and I would reserve my opening until after the close of the prosecution case. So it's a tactical question, a strategic question. But look at this. What are the reasons for not doing it? Not enough time. Well, that's everybody. There's no question. Not effective before a judge or jury. I'm going to show you data that's the judge won't permit it. Well, that's I was actually at Venice Beach this weekend. I saw a skywriter, a planking guy, and said, judges aren't even many judges here are not even allowing closing arguments, much less opening statement. If they're not going to allow a closing argument, what are you going to do if you try and do an opening statement? They're kind of like apoplectic. But look at what the ABA says. ABA says that parents' attorneys should request the opportunity to make an opening statement and closing arguments. These arguments can help shape the way the judge views the case and therefore can help the client. It's like a preview of coming attractions. Now, my argument is that if you think it's the kind of case where you need to make an opening statement, ask the judge to make it. If the judge says no, then cite to the ABA rule that basically is defining competent parents' attorneys. I'm not saying you do it in every case, but if you think there's a good reason for it, this is the standard you can quote to the judge by saying, hey, you want me to be competent under 317? Here's the standard for competence of parents' attorneys, according to the American Bar Association. Now, here's empirical evidence. We have lots of empirical evidence. I mean, all the way back in the early 1980s, when Bergman wrote his book on trial advocacy, he included a lot of psychological studies in which they showed that judges, especially judges like dependency judges, who have heavy caseloads with factual scenarios that are recurrent and similar, a couple of things happen. They form generalizations. This case is like the other 300 I've heard before. Okay? And the other thing they do is because they have this repository of experiential information, when there's a hole in a case where a fact doesn't exist, they will fill in through the other cases they've seen to form a whole. People like pictures. People like full stories. Judges have this much bias as anyone else. So what the data has demonstrated is by presenting a 1 to 2 minute or even a 30-second opening statement, you may be able to demonstrate to this particular judicial officer that your client and or your client's case is sui generis. It may look like every case you've heard before, Your Honor, but here are some differences. The other thing, and again, this is strategic, I'm not saying to do this is just things to think about. One of the things that qualified, effective advocates do is they soften the blow of negative information in a short opening statement rather than having the department do it. A little less important here because the judge gets the file, they have all the data, but sometimes characterizing the negative information initially in an opening statement may be helpful. Same thing with closing arguments. There's a lot of data to show that a closing argument can be very effective. So, am I saying that in every case you have to do this? No. Am I saying you need to think about it? That you may have, at least according to the ABA, an ethical responsibility if you think an opening and closing argument can help your client to proffer those? If the judge says no, well, again, all that's happened is you preserved another potential argument for the appellate attorney that this judge on a routine basis refuses to allow counsel to engage in what the ABA says is competent representation. So I'm not giving you answers, I'm just pointing out issues. Questions about opening and closing? No, I'm not going to. It's not fair. Issue number 6, how are we doing? We have 10 minutes. I got to finish up so we have more questions. Got this question. Technology. Okay. Yeah, I'm going to answer a technology question in 2 minutes. But the question is, in attorney-client communications, what are the rules of ethics? So I can tell you what the rules of ethics are, but I can't give you exactly what to do. Okay, California Formal Bar Opinion 2010, right? Rules on the duty to preserve confidentiality, control, and encrypting email may be necessary, and setting up firewalls may be necessary. Here's the rule. The greater the sensitivity and danger of disclosure of information, the more protections in the form of communication you must take. It may mean this data is so critically confidential that you simply can't put it in an email. That you can only do it in a phone call from a landline that can't be tapped by a satellite. So these are, we're just talking standards. California Bar Opinion, rules do not impose greater or different duties upon a practitioner operating in the cloud where you have a third-party contractor. It's the same thing. So they've held that if you're operating off a cloud in terms of client confidentiality, it's going to be the same rules applied. This is a really important rule. Rule 1-100. Ethics opinions and rules from other bar associations may also be considered. In other words, any rule that's been promulgated on any ethical question in any jurisdiction, including the ABA and any other state bar, is persuasive evidence on how you should conduct yourself, as long as what? It doesn't conflict with an expressed California rule of professional responsibility. I often, in terms of my appellate briefs, and amicus briefs, will quote language from other states or from the ABA's ethics rules and argue that it's strongly persuasive of what should happen. But what you can see the ABA, when we talk about timely question, May 4th, they just promulgated a month ago, basically. May 4th, they promulgated a new set of regulations, Rule 1.1, that pretty much mirrors California's rule. The greater the sensitivity, the more protection you must make. But what they kindly gave us is the variables that lead to reasonable communication. This is what we should think about. First, the sensitivity of the data, part of California's rule. Likelihood of disclosure, part of California. The cost of safeguards, that wasn't included in California. They're saying that if it's going to cost an organization like this, half of its budget, that's a factor in considering the ambit of the technological decision. Difficulty of implementing the safeguards, how safeguards affect the attorney's ability to represent the client. For me, in this, in Ladle, that's a really serious variable. If we can't email our clients or we can't contact them because they're always moving around, maybe what's reasonable in terms of communication may be a little bit different. But again, what's important in these rules is it says, both in the California rule and the ABA rule, that you can get your client's informed consent on a particular kind of communication. So a client can give informed consent. I'm not saying your clients can give informed consent, if they have the capacity to make a reasoned choice among alternatives, and therefore have competency to make that kind of decision to waive what might be a little bit riskier mode of communication, then the rules provide that you can rely on the client's informed consent. Is there a duty to report attorney misconduct? That was another question that was posed to me. The answer in California is no. The ABA has a duty to report information which affects truthfulness, credibility. California does not. Okay? It does not have that rule. So California has not adopted the model rule. It says, if you know, you shall inform. The San Diego Bar in 1992 basically said the same thing. And on May 16, 2016, this commission again considered whether or not to adopt Rule 8.3 of the ABA. They rejected it. So as of this point, as far as I've been able to determine, that is not one which is now up before the commission for changing. So the answer at this point is no. We do not have a duty to report. Now, having a duty to report, excuse me, and discretion to report are two different things. One of my good buddies, for those of you who've been kicking around a long time, Gary Sizer, who was the head county counsel down in San Diego, and I used to do a dog and pony show where we'd go around and I would be the white knight representing kids and parents, and he'd be the black hat representing the department. But we would have these debates. Well, he had, there was a case we were working on together. I mean, he was on one side, I was on the other side. We're not working together, but we're working on a case. And I filed an amicus brief, and I get a call from Gary. And Gary says, Bill, I'm going to have to turn you over for an ethical violation. So what's new? Everybody else does. And so I said, what do you mean? He said, well, you know, I looked up your bar record and it said you're a law professor and you just went inactive about a year ago, and you can't represent clients. So you violated, you were practicing law without a license in filing your amicus brief. So we just had a good discussion. And I, you know, for him, it would be wise to turn me in because they might quash my brief, and I had some good arguments against him. So it would be good advocacy for his client to do that. So I, that night, to beat Gary to the punch, I did all this research. I wrote a 14-page brief, basically demonstrating that representing yourself, because I didn't represent anyone but myself. Thank God I didn't. I was the director of the Center for Children's Rights. I didn't do it on behalf of them. I did it on my own as a citizen. Was able to demonstrate that it is not practicing law without a license if you're only representing yourself. So, in fact, the rules of court in California for filing an amicus brief says any person can file. You don't have to be an attorney to file an amicus brief in California, any state in the nation. So, but there could be strategic times at which you would report misconduct. So that's it for the presentation. Now, any questions from the other offices or any questions here? So what I'm gonna do in part 2, I'm going to address these commission changes in the rules of professional responsibility. I'm going to talk about caseloads, and conflicts of interest will be the predominant themes in those. So if you have any specific questions about those areas, you can forward those to the supervisor who can give me the questions. I can do some research and come in and we can talk again. Thank you.